Hello everyone, welcome to LawPutra YouTube channel. This is Advocate Garvit Jain. The case of Sunil Batra versus Delhi administration and others stands out in our legal history as a landmark judgment that helped secure the fundamental rights of prisoners. It was unique in a multitude of ways, one being that the petitioner in question was a convict of death row. Something very much unheard of at that time. It brought a light of a host of issues, including the clashes between various fundamental rights and the Prison Act of 1874. Furthermore, it exposed the poor treatment of prisoners, with many being subject to torture and sexual abuse. It went a long way in shedding light to the alarming behavior exhibited by prison officers towards the inmates. Facts of the case was the prisoner in question, that is Sunil Batra, was a convict serving a death sentence at the Tihar Central Jail. He wrote a letter to a judge of the Supreme Court entailing the poor living conditions and questionable treatment of inmates at the jail. In his letter, he also complained of the brutal assault and torture by the head warden Magar Singh of another prisoner Prem Chand as a ploy to extract money from the victim's visiting relatives. This letter was converted into a habeas corpus proceeding and by that extension treated as public interest litigation under the ambit of Article 32 of Constitution by the Supreme Court of India. Following this, the court issued a notice to the state and the concerned officials as well. It also appointed Dr. Y.S. Chittal and Sri Mukul Mudgal as amicus curiae. Amicus curiae is a friend of court and authorized them to visit the prison, meet the prisoner, check the requisite documents and also interview the necessary witnesses so as to ensure that they were as well informed as possible about the relevant details surrounding the circumstances and chain of events pertaining the case. The amicus curiae, after paying a visit to the prison and examining the witnesses, reported and also confirmed that the prisoner had sustained a serious anal injury. They reported that in the process of torturing said prisoner, a rod had been driven into his anus. The prisoner suffered from continuous bleeding as a result of this. Due to the bleeding not ceasing, he was removed to the jail hospital and later transferred to the Irvin hospital. It was also reported that the prisoner's explanation for the anal rupture was the failure to fulfill the demands of the warden for money. Now, furthermore, attempts were made by departmental officers to cover up the crime by overawing the prisoner and the jail doctor. Officials also offered excuses claiming that the injuries were self-inflicted or due to piles. Now, the court raised issues such as whether prisoners were entitled to the same rights and standards as a regular human being. Did the Supreme Court have the jurisdiction to entertain the petition of a convict? Next issue were whether the fundamental rights, notably Article 14, 19 and 21, were applicable to one who is detained. Next, addressing the brutal and abject conditions in prisons, which took primacy, the aforementioned petitions act on fundamental rights enshrined in the Constitution. Questions were raised in relation to Section 30 of the Prison Act 1894, which says to confiscation of prisoners' property and also solitary confinement of those on death row, and also Section 56 of the Prison Act 1894, which says jailer or his subordinate, if found to breach his duty or doing anything against the law or regulation, shall be punished with imprisonment as they were supposedly in violation of Article 14 and 21. Furthermore, questions were raised as to what amendments and changes were to be undertaken in the future with regard to the Prison Act. Arguments of petitioner. Firstly, it was argued that Section 30 subsection 2 of the Prisons Act did not authorize the placing of a prisoner under death sentence in solitary confinement, and that jail authorities did not have the ambit to claim this power on the basis of it enforcing Section 30 subsection 2. In spite of Prem Chand being a French citizen, he was still entitled to protections under the fundamental rights 14, 20, 21 and 22, as that was the only human things to do. The petitioner challenged Section 30 subsection 2 and Section 56 of the Prison Act 1894 and paragraph 399 subsection 3 of Punjab Manual Act that was against the fundamental right under Article 1421 of the Constitution of India. While it was only natural that some of the rights of the prisoners would be on their conviction, it was necessary to defend what rights that remained and ensures that the prison authorities did not arbitrarily take them away. Section 56 of the Prison Act should be done away with as it violates Article 14 of the Constitution. Now the state argued that Section 30, subsection 2 of Prison Act did not mention anything about the safety of the prisoners, and instead of placing the blame on the jail authorities, the court should look to give a more elaborate definition to this section so as to prevent the inhumane behavior of prisoners. The respondent side also argued that irrespective of whether the detainees have the right to life and individual freedom under Article 21 of Constitution of India, the state as per the law still has power to restrict the liberty of prisoners. This is due to the possibility that the prisoner may attempt to harm himself or any of the other inmates if he is not kept separate. The state argued that this is why Section 30 subsection 2 of the Prison Act should be upheld by the court. The respondent side also argued that the state of mind of a prisoner under a death sentence, there was a serious chance of the prisoner attempting to commit suicide or cause harm to others. Owing to this, Section 30 was absolutely necessary in the eyes of the respondents. It was also argued that in accordance with Section 46 of the Prison Act, the superintendent is empowered with the authority to examine the prisoner and impose necessary punishments. Essentially, they said that everything that was done to Prem Chand was justified under the law. Judgment given in this case was the Supreme Court held that face-to-face Article 32 and Article 226, it had the power to intervene and restore the fundamental rights of the prisoners. That is, it was completely within the authority of the Honorable Court to intervene and protect prisoners from harsh or inhumane treatment. Also, it was made clear that during the prisoner's time in jail, the jail authorities do not have any right to punish, torture, or in any way discriminate against them without the explicit permission or orders of the court. Only the court had that right. Moreover, in spite of Section 30 subsection 2 of the Prison Act vesting jail authorities with the power to keep a prisoner in a separate cell, the provision was not to be misinterpreted as a right or freedom to torture inmates. This is because the prisoner still possesses the right to life and liberty. It was made clear that Section 30 subsection 2 of the Prison Act was in violation of Article 21. This is because the freedom of prisoners can only be curtailed when there is clear breaking of the law. This section was considered too arbitrary as it did not highlight anything in particular with regard to the need for separate confinement to have the support of the law. The court also found that Section 30 subsection 2 not to be in violation of Article 14, as prisoners under death sentence may run the risk of being a danger to another prisoner and jail authorities. As such, keeping them in separate cells was seen as necessary. The Supreme Court also held that a prisoner under a death sentence does not come under the ambit of Section 30 subsection 2 when there are still chances of getting the decision of the court reversed. If a death sentence given to any prisoner is final and irreversible, then and only then can the said prisoner to be kept in a separate cell under the provision of Section 30 subsection 2. It was held that Section 56 of the Prison Act should be trimmed and controlled by the courts as it was in violation of basic human dignity. Similarly, the superintendent's power under this section were to be kept under check as well. Rehabilitation of convicts with humiliation and disrespect was not seen as the best course of action by the court. It was also held that the definition of solitary confinement was wrongly interpreted by the jail authorities. As a result, the court held that under subsection 8 of Section 30, solitary confinement meant to restrict the prisoner from talking to any other prisoner, but this did not necessarily means prisoners should be kept out of the view of other inmates. Moreover, Section 56 of Prison Act empowered the superintendent to take necessary precautions by putting the prisoners in irons But they were allowed to do that only when such orders were duly confirmed by the local government, and they could not do this on their own discretion power. In this specific case, Premchand was kept in a separate cell with iron without express permission from the local government. As a result, the superintendent was liable for his actions. Thank you for watching.